I have a John Abrams. That's you?
Yes.
22-40065 is now called. The state of Texas versus John Michael Abrams, who is present with his attorney, Mr. Dusler, and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here?
Yes, sir.
Do we proceed in summary?
Yes, sir.
In summary, this indictment alleges that, are we just going on paragraph 1?
Yes, sir.
I was just confirming that, Judge, if
I
you
mean,
would,
Sure.
I think you need
This
to.
is the third time you've
Yes,
been
sir.
charged with this?
Yes, sir.
So what's our plan? I
Well,
mean, we got a
We have an agreement for 10 years, Judge.
Yeah, but
He only
so
received on those
let me ask you
prior.
this,
Yes,
what
sir.
is he looking at if the whole indictment was pleaded to?
As it would be a second degree because,
You know,
hang on, Judge. It's a second degree based upon count 2. With count 3, you can make an argument that could make him look at habitual,
what,
but the case
why
law.
wouldn't there be certainty about it? I mean, what's the argument about? I mean, if the way it's pleaded, it's a habitual felon. 25 to life.
Yes, sir.
Well, I know the people who put me in here, they don't really appreciate sex offenders who don't properly register.
I
I mean,
agree with you.
They don't stand for it.
I agree with your honor, and my agreement that's been offered to Mr. Dusler is 10 years in light of the fact that he only received a 2-year and a 3-year sentence previously. So it's incrementally more. It's not to the degree that your honor is suggesting, but that may be, I feel like 25 is going a little more than what is entitled.
Well, the
Appropriate for this
legislature didn't think that. But he's
I
looking
don't
at
disagree.
life imprisonment, actually. It's a minimum 25.
Yes, sir.
Where was this original conviction? Out of Harris County?
Yes.
Sexual assault of a child. Um, Anybody want to explain what the consistent problem is? I don't have a consistent problem with they get hit and understand that we're serious. You may not, but you're one of the few on the planet who don't seem to appreciate sex offenders have strict rules they must follow because they failed on the rules. You'd like you. But not only have you committed an underlying serious crime involving sexual assault of a child, but this is the 4th time at least you have been charged with a felony offense regarding sex offenders. I don't begrudge the defense. Y'all doing the best you can, but can anybody explain to me, help me out, why any mercy should be shown under these circumstances?
If I may
We're
speak,
involved, keeping in mind a child was injured for the rest of their life.
I don't know the underlying offense originally
Well, it
because
says what it says.
it was way back in 2002.
Well, it's in the body of
Yes,
the charge.
it was in 2002 is when the offense originally happened.
Yeah, I'm looking at the probable cause affidavit is in Harris County involving a 14-year-old child. Sexual assault of a child over a 14-year-old. So there you go.
Since then, what we're looking at are offenses of omission rather than commission. He was originally, the first one occurred just a few months after placing on probation in 2012. It looks like everything was done fine until 2016, some 4 years later, when we had another issue. It's now been 7 years since that. Granted, he's not doing exactly what he's supposed to do, but in not doing exactly what he's supposed to do, but in view of the fact that he received 2 years
How old are you?
TBC.
How old are you?
46.
At this rate, we'll see him 4 or 5 more times before
Well,
he's down to a life.
I don't think
At
so.
this rate of consistent misbehavior.
Is the point is he got 2 years the first time, 3 the next time. This is, as Mr. Ham pointed out, incrementally a whole lot more than.
And how's that working?
Circumstances.
How's that deterrent?
We're gonna find out after a 10-year sentence.
No, he should have stopped after the first one. I don't take that deal.
I think a juror in this county would be more appreciative of making the decision as to whether the minimum of 25 or up to life are appropriate under his consistent misbehavior of a case. And this court is not going to stand for it being light on sex offenders, especially when you offend on a child. That is it. Next is what?
Now that's what I'm talking about. That's a judge that we need to have in office to protect our communities. We are so accustomed to seeing over and over and over again these cockroaches, these monsters, that they change the life of a child, as Judge John Stevens stated. And then to have the DA start off by saying that we want to offer him a 10-year deal in light of the fact that it's a much longer sentence than the 2 prior convictions that we gave him. I mean, look, he served first 2 years and then he served 3 years. So look, it's so much more. I mean, come on, in light of the fact that he served 2 and 3 year sentences before, 10 is great. Judge Stevens says, what? In light of the fact that you gave him a little slap on the wrist for not filing, it's great? Can you believe the man in the blue suit in the where we don't see his face, his back's to us, right? That's the assistant DA, and he's agreeing to give a deal, and he tells the judge, well, in light of the weaker sentences that we gave, this is really great. Can you imagine? He's elected into office. He starts arguing about the legislator. Well, 25 seems too strict. No, it's not. This is his 4th conviction around this defense, as he said, his 4th felony offense. It altered the life of a child, a 14-year-old girl. He's 46 now. This would have happened about 20 years ago. He would have been 26 years old at the time when he did this. And then as soon as he got out of prison, he didn't follow the rules. He didn't register, and they locked him back up. And then as soon as he got out of the prison, then he didn't follow the rules. He got locked back up. Registering, it's clearly, it's critical to keeping the children safe. And it means that what do you think he's doing when he's not registering? What redeeming factor is there where you want to gamble on the life of a child? And his defense attorney says, well, 10 years. We'll find out. We'll find out what happens after 10 years. What? How can you even say that and sleep at night? We'll find out? You want to find out? You want to risk altering another child's life to find out? You want to flip the coin? Eh, we'll find out. Now this judge, he's going to make it go to trial. He's going to see what a jury feels, which most of us feel. But we are tired of seeing this. And if you're accustomed to my other channel, we cover hundreds of hearings of these offenders that get just little slap on the wrist. And what do? They get better and better at offending, better and better at not getting caught. And they get these little light sentences over and over and over again. And we hear DAs that go and issue press releases and say, we're tough on crime. We're protecting your children. They say things like, we don't want to go to trial. It's uncertain at the outcome, so we made a plea deal. Well, the victim doesn't want to get on the stand. We made a plea deal. Well, we have seen over and over again where the victim says, I wanted to get on the stand, but the DA wouldn't let me. They wanted a plea deal. We have seen those cases. We've recorded it. We have seen the survivor get up and say that at their parole hearings. And here's a perfect case. Here's a case where you don't need to have a survivor get on the stand. Here's a case where you violated not registering. You could take him to trial without involving a child getting on the stand.